Welcome to Bloomberg Law. I'm Lee Pacquiao. As the investigation into the Trayvon Martin tragedy progresses, the so-called stand your ground laws in the books in Florida and 24 other states around the country have garnered a lot of attention. The question now is whether the killing of an unarmed teenager by a self-appointed neighborhood watch captain in Florida will lead to changes in these controversial laws. Joining me now to discuss, we have Walter Olson. He's a senior fellow at the Cato Institute Center for Constitutional Studies, and he's the founder of legal blog Overlawyered. Walter, thanks so much for coming in. Welcome to the program.
Thank you.
So before we get into the law itself, first I wanted to ask you, you're not so sure that stand your ground is actually going to apply or should apply in the Trayvon Martin case. Why is that?
Well, in fact, on the facts that we have on the record now, it looks like it will not make any difference at all in whether George Zimmerman is found guilty or not. It may make some difference along the way in procedure in exactly how the state has to get to that point. But as far as whether he's guilty or innocent, no effect at all, as far as I can see. If you take Zimmerman's story, the law doesn't apply, mostly because he will claim that he did not have any easy way of retreating once they were scuffling. And it's important to remember about this law. It does not mean that someone loses their right to self-defense if they have gone out foolishly to a place where they shouldn't have been. If they, no matter how many mistakes they've made, how many bad things they've done, it only kicks in at the point at which violence is about to occur.
And it's a reasonable standard, right? The standard is reasonableness here?
The standard is not just reasonableness, it's a reasonable fear of death or serious bodily injury that makes it necessary to use the lethal force. So there's several different points in which prosecutors can and do shoot down the standard of self-defense, which in fact is not that different from the standard in non-self-defense states. The idea that's gotten around that somehow the law sanctifies irrational fear and it's okay to shoot if you're afraid, not at all what the law does. It has to be objectively reasonable, and that means a lot of people in Florida who try to claim self-defense don't get anywhere at all with it.
Stand your ground laws are relatively new adjustments to very old laws that have been on the books for a long time. What's wrong with the duty of retreat? How did we get to this point where all of a sudden half the states in the nation have a relatively new standard for criminal law in this particular instance?
Well, historically, it's shifted back and forth, and there have always been a lot of states that rejected the duty to retreat. States have shifted back and forth over time, and it's true. Over the last 5 or 8 years, there has been more of an organized campaign to convince states that there needs to be a robust right of self-defense. And when we talk about stand your ground laws, it can be a little confusing because the law in Florida and the laws elsewhere do a lot of different things, of which doing away with the duty of retreat is only one of them. It also changes the rules on confrontations within homes or in schools or in other places. But for purposes of the Trayvon Martin case, we look at just the confrontations in public places. And there, the issue is who had a duty to retreat, if anyone.
In your writings on the stand your ground issue, you've made a distinction between a defense to prosecution and an immunity. Could you talk to us a little bit about that?
Yeah. The one thing that is significant that Florida did that probably does affect this case to some extent is they changed, and it sounds very dry and very lawyerly, but they changed it from a defense to an immunity. And that does a couple of different things. It puts the defendant in a better position if they've been prosecuted and it turns out that they can show self-defense. It gives them more rights. Florida also specifically forbade prosecutors from or police from arresting or going forward with charges without probable cause to overcome the self-defense. And it's interesting to what extent that's going to make a difference here, because clearly when they were having the argument within the police station and the outside state's attorneys said, no, looky here, we have to prove probable cause or else we cannot arrest him. They were citing the text of that law, and yet many legal scholars say that that was already the standard that courts were enforcing even before Florida acted. So what Florida may have done was to codify something that they knew they were supposed to do, which is get a complete pile pile of probable cause and underline it and say, we really mean it and you have to do this. So it may have made a difference in practice. Police departments probably were arresting some people without probable cause. Gets us into a big area involving the rights of a lot of other people.
Just in the last couple of days, we're seeing a lot of movement on the political front dealing with Stand Your Ground. Some Democratic lawmakers in Florida are calling for an outright repeal of the law. The governor is now in the process of creating a task force to examine the law. We're also seeing reports of protests in other states around the country asking to repeal their version of Stand Your Ground. Where do you see this heading? Do you see any chance of Stand Your Ground being repealed in Florida? And what does this mean for the debate in other states?
I think the governor of Florida has the right idea, which is to call together a study of what the law says, whether it went wrong in some way in this instance, whether it might go wrong in other instances, because the law is full of provisions that have been criticized and defended, but which don't have anything to do with this case. It is a good opportunity to study it in the light of intense public scrutiny, and if it needs fixing, then to fix it. I think that the call, let's repeal the law and everything in it, is a kind of knee-jerk response, because most of what's in the law, by everyone's admission, has nothing to do with the Trayvon Martin case.
Mm-hmm. The co-sponsor for the law in Florida has signaled that he's open to tweaking the bill. What would you point to specifically that needs changing?
Well, I think everyone would look at the question of what do you do when you've got a lot of reason, but perhaps haven't quite reached probable cause. Is it permissible to have a special procedure, maybe to take the person into custody, charge with a lower charge, which could be upped later? I'd like to hear the different suggestions and the arguments for why they would be consistent with due process. At the same time, I think some of the criticism of other aspects of the law, such as the widening of the right to use force in defense of property or in cars, I actually think some of that is interesting enough that those parts might also be worth revisiting. So again, the thing to remember when talking about rushing to change the law is that after Florida passed its law, its homicide rate per capita went down, not up, and its violent crime rate is way down below 2005. Now, other states will have other experiences. The fact is that the expected and I'm not arguing that the laws have been beneficial, just that the argument from the other side, there must be a lot of bodies on the ground because they passed the law. You count the bodies and you can't find that effect. It doesn't seem to have produced the Wild West mentality that the other side was expecting.
Right. It's hard to look at statistical analysis in the whole Stand Your Ground story. Justifiable homicides, I believe, nationwide are up as a result of this legislation being passed. Did I get that right, or is it just in Florida?
Definitely. Homicides in which the defendant or prospective defendant successfully asserts a self-defense justification are up. And what's happening here, it would be a leap into the unknown to say that therefore there were some shootings that would not have taken place otherwise. The main thing that is clearly going on is that people who could not successfully make the defense before and would therefore have lost a prosecution are now succeeding in saying, look, this law was meant to cover me. And both sides can offer anecdotes, and both sides have in the press coverage, ones where for some reason courts listened to and accepted very odd-sounding claims of self-defense, and other ones where people who probably would have been convicted, even though they had a tremendously sympathetic claim and they were clearly the innocent person, those people are not going to go to prison for long periods. So, yeah, it's legitimate to air the anecdotes on both sides, but don't assume that more people have been slain because of the law, because the numbers do not show that as far as we can see them now.
All right, tough stuff. Walter, I want to thank you so much for your time today, sir.
Thank you.
That's Walter Olson, Senior Fellow at the Cato Institute. If you'd like to learn more about the cases and issues we just discussed, be sure to check out our offerings on BloombergLaw.com. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Lee Packia. Thanks for watching.